Hey guys, and welcome to today's video. We've got two clips to go through, and the first one features a Karen who's trying to get protection ordered against her neighbor and the neighbor's mom, but things don't exactly go the way she planned. Before we jump in though, I want to take a moment to thank today's sponsor, Chapter. Most people on Medicare end up paying hundreds, sometimes even thousands of dollars every year simply because they choose the wrong plan. It's not really their fault. They often get pushed into plans that aren't right for them by brokers who are more interested in making money than helping people. That's why I partner with Chapter. They started their company after seeing their own parents fall victim to this kind of greedy tactic, and they decided enough was enough. When you call Chapter, you'll speak with a real person who will walk you through all the available plans to find the one that's best for you. And the best part? The call is completely free. With the average senior saving over $1,000 a year, who wouldn't want a little extra money back in their pocket? So give them a call at the number on the screen or visit the link in the description and let a real human review your options to see if there's money to be saved or if you already have the best plan for you.
All right, Ms. Shear and Ms. Woodward, if you would both activate your audio and videos, please. And if you would both raise your right hands. Testimony in this case to be the truth, whole truth, and nothing but the truth.
Mm-hmm. Yes, Your Honor.
Thank you. All right. It looks like, to me, this issue's already been decided.
Yeah.
So,
No.
Ms. Shear, looks like Commissioner Wool signed an order on the 7th of July adding the children's names.
Yeah, I also requested a modification because Alana is not respecting my boundaries at all. She beat me up and assaulted me, and I don't want my kids playing around her kid, and she will not respect that. And she says it's not fair, but she should have thought about that before she beat me up because I will not allow my children to be around any of them ever. And she had cameras pointing towards my home. I don't feel safe. I don't feel comfortable. They need to be respectful and leave me and my family alone. The judge didn't order it a distance that she needs to stay away from us, and I would appreciate if you would do that. Your Honor, the problem is that we are direct neighbors, so we need some kind of thing like distance that she needs to stay away from my children and I.
Right. I understand what your legal issue is,
And I also want you to know that I'm also here to request a protection order against her mom because she tried to run us over.
I'm sure you're not going to get anywhere unless you only wait until I ask you to speak. All right. The question I have here is, it looks to me like the judge already has reviewed your petition that you filed, pointing all of this out, and decided the only thing he was going to do was add your children to the protection order. And he specifically made a choice not to put a distance restriction in because you are immediate neighbors. I think this issue has been resolved. He filed an amended order adding your children, but he decided not to change or add a distance restriction. He read your petition and decided not to do that. So there's nothing for me to do today in this regard. So you did not get what you asked for as far as the distance restriction. He did say that your children are added to the order. So I can't go back and revisit another judge's decision. Ms. Shear, just address that issue, please.
Can you at least tell me what this order does so that I can understand what this order is doing?
Here, let me explain. Since at least one of us was paying attention, the newly modified protection order now includes your kids. That means everything the other person was already prohibited from doing to you now also applies to your kids as well.
All right, this order directs Ms. Woodward to cause no harm to you and your children. It tells her to have no contact with you or your children. Ms. Woodward is not to go onto your property. Or the daycare or school of your children. And Judge Wool made very clear that this order does not exclude Ms. Woodward from being on her own property. And those are restrictions. Now, the complaints you made earlier that you were assaulted, I don't know if that was prior to this order or not, but that's up to law enforcement. That's a crime. They can choose to make an arrest. They can choose to forward it to the prosecuting office. Enforcement of the order is up to the sheriff's office or the police.
The order was because of the assault. That is why I got the protection order.
All right, so you have an order, and whether Ms. is charged or not is not in the process of this order. That's up to the law enforcement. Hold on, we're not going to argue. You're just going to listen. You've asked a question. I'm going to give you some information. So you have an order that tells Ms. Woodward she can't have contact with you. It doesn't matter where you are, she can't have contact. So if you're telling me she's had contact, then the challenge for you is having evidence of that contact, witnesses or video or whatever that you can show to law enforcement to say, look, she's violating. The fact that there's not a distance restriction doesn't mean that the sheriff can't enforce it. They can. If there's proof that Ms. Woodward has had contact with you or your children after the entry of this order, then that's up to the law enforcement and the prosecutor's office to decide whether there's something there they can do to enforce that order. So do you understand that?
So I did call the police after Alana was sitting near my children, and the police said that it doesn't state in the order a distance.
That's correct. It does not.
They were confused that she can't be near my kids.
It doesn't say she can't be near them. It says she can't have contact with them. She can't say anything.
I don't want her near my children, and I have that right as a parent. I want her to stay away from my children.
Thank you, Ms. Scheer. We're going to end this on this particular case because the decision has been made. I cannot change another judge's decision. So as to Ms. Woodward, that decision has been made. I see you filed a petition regarding Ms. Paz, and I'll deal with that in a moment. But as to Ms. Woodward, that decision has been made by a judge. The decision says Ms. Woodward is to have no contact with your children. So that means she can't speak with them. She can't touch them. Doesn't tell her she has to be any distance from them. Just says she can't have contact with them or with you. And the judge was very clear about that. And that's the final decision on that.
Well, as a parent, I'm going to say my kids cannot be near her at all.
That's fine. That's fine. You make those parental decisions.
Oh, I am.
Well, good for you. If you believe keeping your kids away from her kids is the right thing to do, I don't think anyone is going to judge you for that. Unfortunately, the original judge didn't find it necessary to impose a distance restriction, probably because she's your neighbor, and enforcing something like that would be really difficult. And this judge isn't about to overturn that decision, especially when both of you simply acting like adults seems like a less restrictive and perfectly reasonable alternative. So, with that settled, it's time to move on to her next protection order.
Okay, all right. Ms. Woodward, you're all done. Thank you.
What about her having cameras pointed towards my house, Your Honor?
I am not addressing anything regarding Ms. Woodward because Commissioner Wool already addressed the order. I'm not changing it. I don't have the right to do so.
No, but what about her having cameras pointed against my house? Isn't that illegal?
Sure.
And harassment?
Okay. I don't enforce the order. That's up to law enforcement. All right, Ms. Scheer, activate your audio, please. Tina Paz is Ms. Woodward's mother. Is that what I understand?
Yes, Your Honor.
Okay. And you describe one incident in here where you say that she drove around you and some friends over the speed limit in the apartment complex, and you said drove a circle around, looks like 3 of you. When did this occur?
This occurred the other day. This occurred on the day before I went into court the next day to get this order. So it had to have been Thursday night.
Okay. Did she say anything to you?
She came speeding at us, and at first I thought it, like I said in the order, I thought it was my other neighbor because she speeds through the complex, but then she was going towards us, so then I thought it was another girl that lived here that had yelled at my children earlier on, and then when she pulled into Alana's driveway at a speed and parked and got out of the car, I said, "Oh my God, that's Alana's mom," and she said, "Yep, sure is." just like that, and then slammed Alana's door as she was going in.
Okay. So.
And yes, my apartment complex has it on video.
Okay. And did you call the sheriff and have them look at the video?
The officers came out, but it was nighttime, so no, they did not see the video, but I did call in and let them know that the video was found by the landlord. Whether or not they saw it, I don't know, because the officer didn't get back to me.
Right. Does Ms. Paz live in the same apartment as her daughter?
Nope.
Does she live in the apartment complex at all?
Nope.
Has she ever said or done anything to you otherwise besides this incident?
Yeah, she's been rude to me always. Even when I was friends with Alana, she had an attitude towards me for no reason. She's not a very nice lady.
Okay. Well, we can't change how people's...
Okay, but don't you see how this is becoming an aggressive harassment towards me? Her mom tried to run me over.
Okay, which isn't a crime. So if law enforcement believes there's a crime there, they can charge her.
What they did was they advised me to get a protection order against her so that they could do something.
Well, that's the thing. They don't need a protection order to open a criminal investigation. What they probably told you is that if you did get protection order and she still kept doing this, then they could use that as grounds to open an investigation on her. But as of right now, you don't have anything.
All right. So has she ever... When was the last time prior to this incident that you had any contact with Ms. Paz?
She's here all the time.
Okay. So every day?
The other day, she's here, yeah, pretty much every day, every couple of days. She's here all the time.
And what's the nature of the contact that you have with her when she's there?
I don't contact her at all. I have a protection order against her daughter. I haven't spoke to her at all. I didn't speak to her before or after the incident.
Sure.
I have no idea why she did that.
How does she
I don't see why this is funny.
Because you
I don't feel safe.
We're not going to get anywhere unless you just listen and answer my questions. What is the nature of her contact with you? What are you asking me to stop?
To be honest, me and Lindsay wanted her 86 off the property because she tried to run us over.
Mm-hmm.
I want a protection order against her at the very least where she can't come near me or my kids again. If I had been holding my 1-year-old child when she drove near me like that, that would have been so scary.
And what makes you think that she did that on purpose?
I know she did it on purpose because she drove a circle around us in a parking lot. I don't think you understand. She drove a small circle around our bodies. We felt the heat on our legs. And then my neighbor talked to Alana, and her mom did that because she was mad that I said my kids couldn't play with Alana's boyfriend's nephew or brother. Mm-hmm. And it's my right, the officer said, to not have people around my children. I don't think you understand the brutal assault Alana did, and now her mom did that. I don't feel safe. And you guys aren't really protecting me or ordering anything that my landlord can do.
Well,
did I have to get ran over before something happens?
Tell me what else happened. Has she ever said anything to you? She threatened you. Ms. Paz.
Yes, that was threatening, what she did after I got a protection order against her daughter.
Anything other than the car? Has she said anything to you? She said, I'm going to get you because you had an order against my daughter. Has she said anything like that?
Does it have to come to that? I don't understand what you're saying. She drove towards me going 20 or 30 miles an hour.
So the answer is no. She hasn't said anything other than the incident. I'm asking, outside of the incident, what else has happened? Do you have an answer?
No, because I feel like I have to die or be injured really bad before you guys will do something. This is not funny to me. You're sitting there laughing. It is not funny to me. This is me and my family's life. I want Alana and her family to leave me and my family alone. I have lived here for 8 years. She's lived here for a year or two.
Or it might just be because he thinks you're completely out of your mind, and the video you provided didn't actually show anything criminal in nature.
I am not going to allow her children to play with my children.
This is not about
I'm not going to allow her to be around my children just because you guys think it's funny. This is a serious matter to me, Your Honor.
Okay. Ms. Shearer, number one, we're not talking about the order with Ms. Woodward because I told you another judge has already decided that. I cannot do anything.
I asked for a modification. How can you not modify it?
The judge already did the modification, added your children, decided not to add a distance restriction. That decision had.
Can I ask you a question? How do you know he decided that? Because I was told that he was adding my children because he was supposed to be added before, and that I was going to court today about the modification. That is what I was told.
That's not what I see here. I see that he saw your petition and specifically wrote on there, he wrote that Ms. Woodward can be wherever she wishes relative to her property. She can't have contact with you or your children. That was made very clear on his order. I cannot revisit that order.
You mean the first order, not the modification?
No, the modification. So I
would like to see that because I don't.
Okay, so we're not arguing that. We're talking about Ms. Paz. You want me to issue a no contact order against Ms. Paz. I need some information from you. I understand what you've told me about her circling around you in her vehicle. Has anything else regarding Ms. Paz occurred that makes you believe she is threatening you besides the automobile incident?
That is all I needed to feel unsafe. So no, that's the only thing that she's done so far. But that doesn't mean more won't happen if you do nothing about this.
I understand that.
The officers believed I should get a protection order.
Okay. Sheriffs always say that because then they can stop an investigation. So if there is a video, I strongly suggest that you call the sheriff and ask them to look at the video because what you're describing is a potential vehicular assault, and that's a crime, a very serious crime. And if they look at the video and are satisfied that, in fact, that's what occurred, they can forward that to the prosecutor's office for filing of a criminal charge. But if they don't look at it, they can say, yeah, go get a protection order, but nothing really changes. So if there is a video.
I'm still very much going to ask them to get that video, very much so.
Well, okay.
But in the meantime, if that is what occurred, don't you think I should get some protection?
So telling people not to commit crimes doesn't mean they didn't commit a crime. So I can order everybody in the world don't commit a crime, but that's not much protection. So if there's a crime been committed, I strongly suggest that you follow up on that.
There was a crime committed. She was driving right for us. We had to move out of the way so she didn't hit us. And then she sped around us in a circle and then flew into it's 5 miles per hour here.
Okay. Well, you may want to get a copy of that video because what you've told me
I don't know how to get a copy of that video.
Well, you can contact the sheriff's office. You can verify with the apartment complex that, in fact, there is a video that shows.
Oh, we know there's a video. Lindsay already verified with the manager's husband that there was a video found.
Okay. And did the sheriff see it?
I told you, I called and requested that sheriff that was here that night to call me back, and he has not. And it might be because it was a holiday.
Well, how do we get you to understand that? It's not about how close or far she is from you. The order very specifically states that she can't have any contact with you at all. However, it doesn't restrict her freedom of movement because she lives right next door to you.
Okay. All right. I don't control the sheriff. I can't order them to do anything. So
I'm going to call that when I'm done here and follow up on that. But I'm just asking you if I can get a protection order for what happened. The more that they get away with, the more they feel like they can get away with.
All right. You need to understand there's a limit to what these orders can do. And you've already found that out on the order regarding Ms. Woodward. Judges made a decision.
understand why she was able to assault me in front of my children and then be around my children.
I'm not the one who made that decision. That decision has been made. I don't revisit it. So that's what the court's decision was. I suspect it was because she lives next door to you and the judge was not inclined to force her out of that apartment.
He doesn't have to. I asked for a distance outside that she needed to remain away from us. That's all I asked for. It doesn't matter. I'll just have to enforce it with my children, I guess. That sucks. My kids will have to leave the park if she comes there. I'm so tired of dealing with this situation. I just want them to leave us alone.
Judge's order regarding Ms. Woodward tells her to do that.
But what about the cameras? She's allowed to have them pointed at my home?
Do you have any video that she's taken from the camera or photos?
How would I have that? We don't speak.
Right. So that's a really hard one to enforce. So that's typically why we don't address those issues on protection orders. Because lots of people do things like that and then they say, well, my camera is just my security camera and take in other things. So I don't see any basis for me to issue an order regarding that. I am going to issue a temporary protection order against Ms. Paz, telling her to have no contact with you or your children, not to come within 10 feet of you or your children.
What about my boyfriend? He is Aaron that she also drove around.
If he wants an order, he has to file a request for an order. Only one person files a request. There will be a hearing on this issue on the 15th of September, just like this. And Ms. Paz served.
Do I get it from the, do I call the civil department to get the Zoom link and everything?
It will be emailed to you.
Okay.
So hold on just a minute.
Okay. Sorry and thank you. I don't feel safe anymore here.
Well, you need to understand that there are limits to what the court can do to a protection order. And if you understanding, stop. If you stand what those limits are and you think that's not enough protection for me, you may have to make different decisions as a parent on what you're going to do. But there is a limit to what the court can do. So you need to understand that. And it may not meet all your needs. So you may have to make other decisions.
Well, how do we get the officers to understand that in the order against Alana, it states that she can't be near us?
There's something about her that just gives me goosebumps. Like she actually enjoys suing people and feels thrilled about winning, whether or not the person even deserved it. And now that she's finished trying to relitigate the case she already lost, she's ready to move on and go after the mother.
It doesn't state that. It says she can't have contact. So, for example,
I wouldn't want to be around somebody that beat me up.
Right. But the court hasn't ordered any distance restriction.
Fortunately, yeah. The officers also have limitations to what they can do. So I feel like there's not a lot of protection here.
If Ms. Woodward yells at you, talks to your children, talks to you, sends you a note, emails you, that's contact. And you can provide evidence of that contact to law enforcement and they can then enforce the order. But if she's outside and you're outside, there's nothing in the order that tells her she can't be there. But if she says things to you or to your children, that would violate the order. So you do have.
So she cannot speak to us, touch us, anything. She can be near us as long as she doesn't talk to us or touch us.
The order says, correct.
Thank you, Your Honor.
And as pointed out, the issue is going to be when you call police is to have some evidence that she's done that. So either witnesses who will tell them that that's what happened, or a video of it happening, or you telling them that's what happened, and they'll decide whether they believe that's enough evidence to go forward. But that's up to them. That's not part of the order.
Yeah, I just don't think they're understanding the order either. They're very confused with the order themselves. They don't see a distance, so they don't know what to do.
Right. Well, the order is very clear in what it says, and they can decide whether there's evidence of a violation of the order. And that's seemingly, to me, that's what you're really frustrated about, is the inability to have the order enforced and their reluctance to do so. And I can't change that. That's
Well, what if my kids are playing with the neighbor kids, right? This is what happened the other day. I'm sorry, I'm not going to keep dragging this on forever. I just want to know if this is a violation or not. She didn't talk to my kid, but so my kids' friends were saying that they couldn't play with her kid because I don't let my kid be around her kid, right? And she was like, "That's not fair. That's not fair." So then my kid went inside to get away from him.
okay. I'm not sure who said that's not fair.
Alana was saying, "That's not fair. That's not fair." And you know what wasn't fair? What wasn't fair is when she came into my house and beat me up in front of my children. That's what wasn't fair.
Okay. Like I said, she can't contact you or your children. So if you believe she said something to your children, provide that information to law enforcement.
Okay. Thank you. Now, as far as her mom, I'll stop bringing up Alana. Let's finish up on her mom.
All right. So that wraps up the first hearing. She walked away with one loss and one win, though it's only a temporary win for now. Her next hearing is scheduled for next week, where she'll have to back up her allegations with actual evidence. And honestly, I'm not sure that's even possible. So, with that done, let's move on to the next hearing. A plea deal case where the defendant is starting to have some last-minute doubts about his decision.
And the mother does not live in the same apartment complex or anywhere near that apartment complex. Is that right?
No, she lives further down the road near the RAC Park. The regional athletic complex in Lacey. She lives near there.
Thank you.
Mm-hmm. Are you issuing that her mom not come on the property, or just that she don't be near me?
That she doesn't, same thing, that she can't have contact with you or your children.
Okay, thank you.
And I've put a distance restriction in here that she stays 10 feet away from you.
Okay. Yeah, thank you. I appreciate that.
What's that?
The sheriff's, I'm looking right now, but if I need to update it, I can.
Okay.
I'm sorry if I seem argumentative today. I just am tired of dealing with this situation. It's exhausting.
Yeah, I understand that.
Yeah, I'm just tired of it. Just want to live my life in peace is all.
Change your type it.
I will, Ryder. I'm trying to finish up with the judge, please. For another minute. We're almost done, honey.
As I said, the next hearing is on the 15th September. Ms. Paz isn't be served. This order can't take effect unless she is served. And
Yeah, I will have them serve her.
Sheriff's office to serve her. So you'll want to stay in touch with Thurston County Sheriff's Office.
Oh, yeah, I'll check in to make sure she's been served for sure. So September 15th at 9 a.m.
All right.
Is it at 9 a.m.?
Yes.
Okay. And then as far as the other stuff, it'll be emailed to me, or I can get it from the civil department?
We'll send you an email today about what you need to do next.
Okay, thank you so much. Bye, Your Honor.
That's exactly the kind of thing someone with an alcohol problem would say. But to be fair, it's also what someone without an alcohol problem might say. That's why they don't just rely on what you claim about yourself and your habits. They also consider other factors to assess the risk level and determine what kind of supervision to recommend to the court.
And then Mr. Samura, I'll call you after I call Mr. Fuentes, okay? Come on up to the podium, Mr. Fuentes. For the record, this is 25T263, People v. Jarian Fuentes, who appears in person in the courtroom. Good morning, sir. All right, so Mr. Fuentes, I know you did your alcohol evaluation. I do appreciate that. I want to make sure that we do have a plea agreement. I don't see one in the file.
We do not have a plea agreement in the file, Judge. The plea agreement was emailed to the email that Mr. Fuentes provided at the last court date. I have an unsigned copy here. if his intention is to go forward with the plea he made, he can review this copy and sign it.
Would you like to review that? Take a few minutes to review it, sir?
I would, yeah.
Okay, you can just sit at that table if you'd like, if that makes it more convenient for you, just to take a look at it. And then I think there's pens there if you want to sign it. And are you ready, sir? Were you able to read and sign that agreement? Oh, sorry. Thank you. All right. For the record, this is 25T263, People v. Jarian Fuentes. Mr. Fuentes appears in person in the courtroom. All right. So it looks like, sir, you would be pleading guilty to driving under the influence. There would be 48 hours useful public service, 2 hours with the victim impact panel, and the alcohol evaluator recommended level 2 and 42 hours of therapy. They also recommended supervised probation. So does that sound like the agreement you wish to enter into today, sir?
To be honest, not 100%.
Okay.
I have been completely out of trouble since 2019, my release from my prior only case.
Mhm.
I have had 0 issues with any substances whatsoever.
Good
This
for
is
you.
my first occurrence of it.
Good for you.
And I have had no issues holding my job for the entire year, this whole past year. I've gotten a promotion. I have been doing very well. And this was a mistake that I made during one night of celebration. And I did try to also voice that in the matter of, I tried to be conscientious in not messing up
That's for him.
bad.
Uh-huh.
Like, I do remember stating that as soon as I began to drive, I realized I was not good to. Pulled over, parked. I'm not the type of individual that I make the same mistake twice. And being that I don't have any history at all with any substance abuse whatsoever, this isn't something that shows a pattern of negative influence for it. It's a breach in pattern as opposed to what it is.
So
If
what
that
are you
makes sense.
asking, what are you saying
It's-
to me? What are you objecting to something in the plea? Is it the supervised part or?
It's the supervised, it's the victim impact. I have
Well,
no
those are requirements,
objective.
sir.
And I did read that part of it. My objection to that is simply the justness of it, not that I have to do it. However, I don't feel that I have done anything to deserve supervised anything. I have been completely clean, out of trouble. This is my only occurrence. I've had one other traffic ticket that I can think of. And that's over the past 5 years.
Well,
I have
printed off.
0 objection to community service. I know that's mandatory. I read that in the agreement. I know that the victim impact is mandatory, even if there weren't any victims. But I don't see why I should be treated like someone with an alcohol problem if I don't have one.
I mean, hey, a DUI is definitely a big step down from attempted murder. But maybe the fact that you have an attempted murder conviction in your past is exactly why they're asking for a bit more supervision.
What I did, sir, is I printed off the alcohol evaluation. I don't know if you saw it, but you can look at it and you can, that they justify it. It's on that last page of the alcohol evaluation. It says that Protective risk factors. Defendant presents with protective factors in his employment and living stability, support system, and willingness to comply with court orders, factors that support supervised probation. The defendant presents with risk factors in his history of criminal involvement and lack of insight as to the risk he posed in the current offense. He scored in the low-medium range on the alcohol involvement scale, but on the high range on the legal non-conforming scale of their assessment. He could benefit from accountability and support to successfully meet the requirements of his sentence. That's what supports their recommendation.
I don't understand their evaluation at all then, because I have never failed in any parole, in anything
It didn't
I've
say
ever
that
had.
you had failed. It said that you,
I show a tendency of failure, but I don't have a pattern of failure.
well, I'm sorry if you feel that it says that you failed. It doesn't say, it has a history of criminal involvement, doesn't say you failed at.
I don't have a
those
history of
cases.
criminal involvement either, though.
I'm looking at your background, sir, and I do see cases 14 CR 77, 15 CR 29. Those, and I agree with you, it's been 10 years since the last case. Well, it looks like you've been here within the last 5 years with Judge.
I had a
Phelps
speeding
in
ticket.
11. No, but these are the felonies. You had a felony menacing in 15 CR 29. You had I think attempted murder is what I saw
2014.
in 2014.
So you're saying that if someone shoots at another person with the intent to kill them, but misses every single shot, then it somehow doesn't count as attempted murder?
So, no, that's all it's saying. It's not saying you failed at those things. It says that there is a history, which is true.
Yeah, but it's over a decade old.
So I guess your option, sir, we can go forward. I'm likely to follow the recommendations of the evaluation and order supervised probation. But I will tell you that, they only interfere as much as they need to. I mean, you're going to be the one that's responsible for getting things done. They'll give you support in doing that.
My issue isn't that, it's with supervised.
Yeah, that's what I'm saying.
Yeah, I have
Because
to
I
go
would
there.
order that. I don't know, do you live in Cripple Creek?
Yes, I do.
Okay, so they are here, our probation officers are here at the courthouse on Monday, so
I was told when I was on parole that I couldn't see them.
parole's different than
I had to
probation.
do it down at their office in
Yeah,
Springs.
parole's different than probation. Our probation officers are here on Mondays and they meet with people every Monday. I mean, they are also coming into court for their cases, but they meet in that hallway down to the right of the clerk's office. They meet here. So it's not going to be that inconvenient. And they may be able to do it by telephone too. It's up, so.
My issue isn't inconvenience, it's unjustness. But
Okay.
I'll go ahead and accept because
Okay, all right. Well, and they may say that once you get everything done, oftentimes I get motions that say, well, he's done everything, we're gonna release him. And I sign motions all the time about people who've already completed their requirements, so.
Your Honor, if I can be frank, I don't have a whole lot of faith in this system at all.
I gotcha. I'm sorry.
I got hit with an attempted murder when no one was hurt.
Okay.
That's all the proof I need, so.
But by your own testimony, you were driving when you realized you'd had too much to drink and decided to pull over. So just because the officer found you parked with the car still running doesn't mean you didn't drink and drive to get there in the first place.
I'm sorry.
I'll do what I got to, and that's it.
Okay. Well, I get it. I'm sorry. Okay. All right. So we're going to go forward, right? Or did you want to set it over for another day?
I'll go forward.
All right. If you could state your name for the record.
Jarian Fuentes,
And how old are you?
29,
How far have you gotten in school?
college,
Okay.
5 years.
Okay. Are you under the only reason I have to ask, these are the same questions I ask everybody, sir. Are you under the influence of any drugs, alcohol, anything that would prevent you from understanding what we're doing here today?
None.
Are you a current or former member of the U.S. Armed Forces?
No.
Do you understand that if you're not a U.S. citizen, this guilty plea could affect your immigration status? I
Born and
know, I have
raised.
to ask everybody. All right. I'm going to run through your rights with you, sir. You have the right to be represented by an attorney at all stages of the proceedings, not just at this one proceeding today, but at all proceedings that may be held in this case up to and including a trial. And if you are indigent and cannot afford an attorney, one would be appointed for you at no cost to you. Do you understand your right to an attorney?
I do.
You also have the right to have a trial, and that trial could be either before a judge or jury of 6 persons who would come to decide the facts of the case. The trial would be a speedy trial, meaning that it would be held within 6 months from the date that you plead not guilty. It would also be a public trial in a public courtroom. Do you understand your right to trial?
I do.
You also have the right to have charges proven against you before you can be convicted of them. You are presumed innocent. The burden is on the district attorney to prove all elements of each charge beyond a reasonable doubt. At the trial, you have the right to testify if you want, meaning you can take the witness stand and tell your side of the story, but you don't have to. And if you choose not to testify, I would tell the jury they can't hold that against you in any way. You have the right to present witnesses and evidence on your own behalf and to have subpoenas or court orders issued to compel witnesses to appear and testify. You also have the right to confront any witness that testifies against you, meaning those witnesses will appear personally and testify to the facts, and you would have the right to cross-examine them or ask them questions. And finally, if you were convicted of the charges after a trial, you would have the right to appeal that conviction to a higher court. Do you understand these rights, sir?
Yes, I do.
And do you understand that by pleading guilty, you give up all these rights, including your right to trial?
I do.
Have any promises been made to you other than those contained in the plea agreement to get you to plead guilty today?
No.
Is anyone trying to force you or pressure you into pleading guilty today?
No.
Is this a knowing and voluntary decision on your part?
Yes.
Okay. All right. So as far as a factual basis goes, do you admit that on or about May 5th of 2025 in Teller County, that you were driving a motor vehicle or had driven a motor vehicle?
I was parked with the engine running, but that qualifies, I guess.
Your Honor, if I may supplement the record.
Sure.
On the date of May, on or about the date of May 5th of this year in the early morning hours, the defendant was contacted by officers of the Cripple Creek Police Department where he was observed sleeping at the seat.
Wasn't asleep. And I tried to tell them that too. I had my cowboy hat on and I was watching YouTube on my phone.
Where he was observed sleeping at the wheel of a parked vehicle. Officers contacted him, were unable to wake him at first contact. There was a breath test in this case. The BAC was 0.133. Standard field sobriety tests were conducted that resulted in 6 of 6 Qs on the HGN, 3 of 8 on the walk and turn, 1 of 4 on one leg stand.
Okay. So Mr. Fuentes, so I guess you've established the factual basis, Mr. Parsons?
I believe I have, Judge.
Okay. So Mr. Fuentes, how do you plead then to the charge of driving under the influence of alcohol?
Oh, I'm pleading guilty because there is no stationary charge. I mean, you have a DUI or you don't.
Yeah, I'll agree with you on that. It's definitely a little messed up, but it's still a whole lot less messed up than attempted murder.
I can't give you advice, Mr. Fuentes. So that's what an attorney is, a defense counsel is for. Mr. Parsons?
Your Honor, case law is very clear in Colorado that there's no requirement of proof. It's not part of the elementals that the people have to establish a trial that a vehicle was actually in movement, just that the key was in the ignition, the vehicle was operational, and that the defendant had actual physical control of that vehicle. Based off the record that the people have supplemented today for the factual basis, I believe that standard has been met.
Gotcha. So, but sir, I can't give you advice about that.
I'm
If
pleading
you're
guilty. I'm just stating it's not a fair standard.
Okay, it's not a fair standard.
Mhm.
Gotcha. Okay. All right. The court will accept Mr. Fuentes' plea, finding that it is knowing, voluntary, and intelligent, made without any undue force, duress, or pressure, that he is not under the influence of any drugs or alcohol, and of sound mind, that he understands the charge against him, the possible penalties, and the rights he's giving up by entering into this guilty plea today. And there is a factual basis for the plea, so I accept that plea of guilty to driving under the influence. Is there anything the people would like to say prior to sentencing that you haven't already said?
People would ask the court to sentence according to the terms of the plea agreement and adopt the recommendations of the alcohol evaluation for supervised probation. I believe the evaluator lays it out pretty clearly. Mr. Fuentes does have, albeit somewhat dated, but a serious felony history in addition to this case. I believe the recommendation for supervision is appropriate. I would further note for the court that there is no restitution the people are seeking in this case.
Okay, none? Okay, that's what I was. All right, and then anything else from you, Mr. Fuentes?
Oh, no, I just kind of found that a little humorous.
Okay, gotcha.
Over a decade.
I understand, sir. All right.
And you want to hold that over my head?
Okay, sir, talk to me, not to Mr. Parsons.
And
okay?
Your Honor,
just to me.
The
Okay.
people consider a class 2 felony attempted murder conviction a serious felony conviction.
Okay, I get it. Stop it. The two of you, you're going to focus on me, Mr. Fuentes. I don't need you to be looking at Mr. Parsons. All right, so,
I state something just for knowledge here,
sure,
please.
go ahead.
And I'm going to refrain from looking at you because I'm speaking to the room.
Okay,
In 2014, I pled guilty to a second-degree attempted murder so that I could get into YOS in Pueblo.
okay,
It was a mandatory, you have to plead guilty to a violent felony in order to get into the program, and that is how I saw a way to get my college education. So if that's going to be held over my head because I chose to take that plea deal, I'm just going to say that's a little messed up.
All right, so that's the end of that video. Hopefully, he can get the rest of his life together and manage to stay out of trouble for more than just a decade at a time. If you enjoyed the video, be sure to hit the like button. And if you didn't, feel free to hit the dislike. Either way, don't forget to leave a comment below and subscribe with notifications turned on so you don't miss any future content. And with that, I'm out.